My name is Frigon. I've been practicing law for more than 30 years. One of my most frequently asked questions is, when should I update my will or trust? My answer is always the same. Time alone does not invalidate a document. A will that was properly signed 50 years ago is still a valid document. Nonetheless, you should keep in mind that changes to the law and changes to your life situation can cause your will and trust to be out of date. If your document is out of date, you will likely have a less than desired result. At the law offices of Bradley J. Frigon, we are committed to making sure that our clients' legal documents achieve their goals when it matters the most. To make sure this happens, it's critical that you have an experienced attorney review your document at least once every 3 years. When updating your documents, there are 3 common mistakes you should avoid. First, do not write or mark on your own will or trust. A self-edited will with writing on it or edits on it will cause extra scrutiny by a probate court and cause unnecessary delay and expense in probating the will or administering the trust. Second, it does not do you any good to change your will or trust unless you coordinate the ownership of your assets. Recently, we have been involved in several cases where the decedent failed to change a beneficiary designation on a retirement account after a long relationship or a divorce. As a result, the entire retirement account passed to an ex-spouse, an ex-partner, much to the disappointment of a new spouse and to other family members. Finally, don't wait too long. Updating a document during a health crisis or after a diagnosis that may impact mental capacity is always more expensive and causes more problems. Please take a few moments to read my article on when to change your will or trust. This article is a good starting place for you to determine if your will or trust is out of date. The article can be found under our estate planning resource section of our website. A couple other points to remember. There's been significant changes to the federal estate tax law in the last several years. If your document was prepared prior to 2009, the estate tax clauses in your document can cause more problems than they solve. As a result, it may be necessary to update those provisions of your document to make sure that they comply with current federal estate tax provisions. Even if your will or trust was prepared by another law firm, we welcome your call to have us review your document. Don't wait until it's too late or there's a crisis. Call our office now for peace of mind, knowing that your estate plan will carry out your wishes in the time of need.